Okay, in these presentations, I will present on the topics the examination of witnesses. The provisions of these examinations of witnesses are provided in the Part 3, Chapter 10, from sections 135 to 166. 135 to 166 of the Indian Evidence Act. These provisions deals about the details provisions of the examinations of witnesses. In these presentations, I will present some provisions only due to mobile technical issue. Okay. Now at first sections 135. Section 135, it provides about the order of productions and examinations of witnesses. Here, this section states the witnesses will be produced as per the provisions of the CPC and as per the provisions of the CRPC. That is, here, Order 16's Rule 1 of CPC, Civil Procedure Code. It provides that about the summoning and attendance of witnesses. Here, after the settlement of issues, the parties to the suit shall present in court a list of witnesses whom they propose to call either to give evidence or to produce documents and obtain summons to such persons for their attendance at court. Here, a party desirous of obtaining any summons for the attendance of any person shall file in court an application stating therein. Yeah, it is expressly given in Order Sections Rule 1. Here, after the settlement of issues, the party themselves, they have to file, they have to list, they have to keep the list of witnesses, and they have to file the applications for the summoning of the witnesses. That is, for the examinations and for the productions of the witnesses. That is, and in CRPC, now section 311 of CRPC, it provides a power to summon material witnesses or examined person present. Here, section 311 of CRPC, it reads that court may at any stage of any inquiry, trial or other proceeding under this code summons any person as a witness or examine any persons in attendance. Do not summon as a witness or recall or re-examine any persons already examined, and the court shall summon and examine or recall or re-examine any such persons of his evidence appears to it to be essential to the just decisions of the case. Yeah, this section 311 of CRPC, it is expressly given that at any stage of inquiry, trial or proceeding of the court, here the court can summon on the application of the prosecution or on the application of the defense counsels any material witnesses for the productions and examinations of such witnesses. Sections 135 provides about this. Now, section 136, just to decide as to admissibility of evidence. Here, when either party proposes to give evidence, here, whether their evidence will be admissible or not, it will be decided by the judges. The judges can admit or they can deny for the admissions of some evidence which may or may not be relevant to the issue based on the discretionary power of the judge. They can deny or they can admit some evidence. It may be admissible or it may not be admissible. Section 136 provides about this regarding the fact which are relevant or which are not relevant. And sections 137, that is, it gives definitions of the examination in chief, cross-examinations, and the re-examination. Here, examination in chief, that means the examinations of a witness by the party who calls him shall be called his examinations in chief. That means the party who has called the witnesses to examine in the court, this is called the examination in chief. That is. And cross-examinations, it means the examinations of a witness by the adverse party, that is by the opposite party. It shall be called the cross-examinations. And the re-examinations, the examinations of the witness subsequent to the cross-examinations by the party who has called him shall be called the re-examination. That means re-examinations after completing the process of examination in chief and the cross-examinations. If the party who has called the such witnesses, if they again call him and if they again re-examine him, this is called the re-examinations. It is. And section 138, it provides about the order of examinations. That means this section provides that some steps it must be followed in the conducting of the prosecution. That means at first witnesses must be examined in chief, after the cross-examined, after the re-examination. This procedure must be followed by the conducting the prosecution. That is 138 directs about this procedure. That is. And it's section 141. Now, this section provides about the leading questions. Here, a leading question, that means any questions suggesting the answer which the person putting it wishes or expects to receive is called leading questions. That is here. Leading question, it means that the questions which suggest the answer only. That means who put the questions? If he only wishes or expects the answer, this is called the leading questions. Here, now the section 142, it provides about the point these leading questions can be asked or cannot be asked. That is, this section 142, it provides it leading questions must not, if objected to by the adverse party, be asked in an examination in chief or in a re-examination except with the permissions of the court. Here, these leading questions cannot be asked in the examination in chief or in re-examinations if the opposite party objects, that is. But it can be asked only with the permissions of the court in the stage of the examinations in chief or re-examinations. Section 142 provides about this. And in section 143, it provides about the when they may be asked. Yeah, leading questions may be asked in only cross-examinations. That is, at the moment of the cross-examinations, whatever the opposite party, they will ask the witnesses. At that moment only, these leading questions can be asked. This here in the court, the witnesses is not allowed to speak regarding the matters under inquiry. They can only answer whatever the question put by the learned counsel. That is, that's why the concept of the leading questions. That is, the questions which were suggesting the only answer. This concept, it can be asked in the cross examinations. And section 146, here questions lawful in cross examinations. Section 146, it provides about the questions lawful in cross examinations. What questions are lawful and what questions are not lawful, which are permitted or which are not permitted. It provides under section 146. Now, in the course of a cross examinations, a witness can, of course, be asked all questions relating to relevant facts. Whatever the questions come under the relevant facts, this question can be permitted by the court to ask by the learned counsels. But in addition to such questions, the witness can also be questions as to his character. That is, here, thus a witness can be asked questions here to test his veracity. That is, whether the witness's truthfulness or not, about his veracity, it can be asked, and about to discover who he is, and what is his position in life, and regarding his status and position in the society, it can be asked. That is, what is the status and what is the positions of the witnesses in the society? It can be asked in the moment of the cross examinations, and to shake his credit by injuring his character. And the witnesses can be checked whether he is trustworthy or not. That is, it may be by injuring the character of the witnesses, it can be asked by the learned counsel in the cross examinations. That is, these are allowed under the section 146. That is, here testing the veracity of a witness means ascertaining his honesty so as to advise the court to what extent the witness is creditworthy, to what extent the witness is credit-worthy. Hmm. Whether this witness is credit-worthy or trustworthy or not, yeah, this can be permitted to ask in the cross-examinations. That is. Now the section 154. That is. This section provides about the hostile witness. Hmm. Here, questions by party to his own witness. Questions by party to his own witness. It is known as the hostile witness. Hmm. Here, this section provides states where a witness makes statements against the interest of the party who has called him. He is known as a hostile witness. Hmm. Suppose if a witness has given evidence, if he is giving statements against a party who has called him to testify, this is known as the hostile witness. This makes it necessary that he should be cross-examined by, by the very party who has called him so as to demolish his states. That is, yeah, due to the statements against the party who has called him, now this party has right to cross-examine such witnesses, such hostile witnesses, to demolish his stance, to destroy, to defend their case. That is, to demolish the stand of the hostile witness, to demolish the stand of the hostile witness. Here, the party who has called such witnesses, they have right to cross-examine their own witnesses. This provision is given under sections 154. That is, and next sections 155. It provides about the impeaching credit of witness. Impeaching credit of witness. Here, impeaching credit of witness, it means that the credit of a witness is generally impeached by the opposite party. That means shares or discredit by the opposite party. But when the witness has become hostile, his credit may be impeached. When the witnesses become the hostile, his credit may be impeached. That means shares. That means allegations can be bring. It can be discredited by the party. That is with the permission of the court, by the very party who has called him. That is here impeaching of credit witness is directly given that whatever the witness the party has called him to examine on behalf of them, if such witness become the hostile, it is, if such witness given evidence against them, they have the right to impeach such witnesses. They can be cross-examined by the party who has called him. That is, impeaching the credit of a witness means exposing his real character to the court so that the court may not trust him. The US in which the credit of a witness may be impeached are given in section 155. These sections permits the under some conditions, under some circumstances, that is, Here, number one conditions, uh, it provides about the unworthy of credit. If the statements of the witness, if the testification of the witness by the very party who has called him, if such party they have believed that whatever the statements given by such witnesses are unworthy of credit, it is not reliable, it is, then they can impeach the credit of such witness. That is, and number one conditions, if the witnesses has corrupt inducements, if the witnesses corrupt inducements, that means the witnesses has either taken the witnesses has either taken bribe or has accepted the offer of a bribe, that is, uh, or some other corrupt inducements for giving his evidence, that is, yeah, corrupt inducements, it means that the witnesses who were given evidence by taking some bribe, money from the opposite party, uh, by taking bribe, by taking money, if such witnesses are uh, giving evidence against a party who has called him to give evidence on behalf of them, then such party they can impeach the credit of such witnesses. Uh, that is, and number third conditions, former inconsistent statements. Number third conditions, former previous inconsistent statements. Here, by showing earlier statements of the witness which contradict his present statements, whatever he have been given in the previous statements, if it is contradict with the present statements, such contradictory statements can be cited only to the extent to which section 153 would permit such contradictions. Here, it has been held by the Supreme Court that the previous contradictory statements of a witness can be used to discredit only his testimony and not that of other witnesses. Yeah, it is also cited by the Supreme Court also. Whatever the contradicts between the previous statements and the present statements, it can be discredited by the party who has called him such witnesses. That is, this is the concept of the uh, impeaching credit of witness. That is, here up to this we have discussed some important provisions. Okay, uh, we have already discussed the order of productions and examinations of witnesses, admissibility of the evidence in relation to the fact, and the definitions of the examinations in chief, cross-examinations, re-examinations, and about the leading questions, and about the hostile witness, and about the impeaching credit of witnesses. Okay, I think we have got a clear concept. We have discussed up to this today. Okay, that's all. Bye. Have a nice day.